get started. I see it's a couple minutes after one, and I know there's lots of questions, so people may still be streaming in, but wanted to make sure to make good use of everyone's time. Hi, everyone. I'm Dave Beanstorfer, President and CEO of United Philanthropy Forum, joined here today by my forum colleagues, Brandon Iraq-Seedlin, as well as Tracy Slater-Rigaud. Brandon's making sure everything works well for us, and Tracy's here to help out in any way she can. Appreciate them both being here today. And appreciate you being here. This is our first Ask the Nonprofit Lawyer program. Hope you all like this new series we've added. There's been so many legal questions that have come up in the last 2 years, and seems to be a never-ending issues that come up with us. So we'll get started. I have a number of questions that have been submitted ahead of time. So I'm going to start with those. And if I ask a question and you were the person who submitted it, you can feel free to jump in to add anything to the question after I read it. And then at the end, if there's time, which I hope there will be, for other questions that you have, we'll try to leave some time for that as well. Jeff, you ready for the first question?
Sure, fire away.
What is the best way from a legal HR perspective to collect and store information related to COVID vaccines for your staff?
Great question. In fact, I just was given a speaking presentation to a group of nonprofit executives here in Tallahassee earlier today, and had that same question actually. And so this is governed by a provision of the Americans with Disabilities Act, a federal law that has the employment related provisions say that when you are storing an employee, it's for employer-employee relationships, not for things like donors or members or other things like that, but in the employment context, and not for independent contractors, but in the employment context, if you have confidential medical information about an employee, the EEOC, the Equal Employment Opportunity Commission, the federal kind of regulatory agency for HR legal issues, says that you should store that information. You should not store that information in the employee's personnel files, and you should store it, separately. Kind of a best practice is to keep like a password protected Excel spreadsheet with the employee's kind of name, and then the salient information from the vaccination cards, like date of last vaccination, whether if you're requiring them to be fully boosted, and all of that sort of information on there, perhaps the name of the vaccine that they received, and that should only be provided access to ideally maybe one or two people within the organization. Like if you have an HR director, that would probably be one of them, maybe the executive director, but it should be securely stored and protected, and not shared with any other group, beyond who actually needs to see that. And for those of you that have imposed or are imposing vaccine mandates for your staff, this is a common occurrence, and it's important to follow those protocols. And of course, carefully protect that information.
Great. Thanks, Jeff. Before I move on to the next question, just want to allow space if anyone had sort of any kind of follow-up to that response.
If anyone has follow-up questions or comments on any of this stuff, please ask. And Dave, I remember there was another question about vaccine mandates.
Yes.
So I'm sure you're probably going to ask that one next.
You
Try to group these together by topics. There were some great questions. I was just reviewing them a few minutes ago. There were some great ones.
Yes. Another vaccine-related question. I would love to know how to legally require vaccines for employment. I'm doing it already with a soft nudge and with a talent pool that is predisposed to vaccination, but I'm not sure I'm following all of the requirements. So I guess the question is, what are the basic requirements we should know about in terms of requiring vaccines for employment?
Okay, so first
I think
off,
that's a big question, but
no, it's fine. It's a critical question in this area. So first off, a lot of everyone reads, hears, watches the news and hears about, vaccine mandates from the federal government and from states kind of being shot down in court in some instances, which has certainly been happening, including the federal government's OSHA Occupational Safety and Health Administration proposed requirement that businesses over 100 employees be forced to impose vaccine mandates. Those issues are being litigated, and we'll have to see how all of that turns out. But that has nothing to do with a private employer like your organizations, being free to impose their own vaccine mandates. That is completely lawful. There is no legal protection for employees who are opposed to that. I will talk about kind of the rules of the road in terms of how you can implement those. But I just wanted to make clear so you don't get confused, because some people have been, that it's perfectly lawful for you to impose a vaccine mandate on your staff. Second thing, it's really important if you're going to do that you do it in a very clear manner. Essentially, you want to have a written policy that sets forth your vaccine policy. And we've reviewed hundreds of these at this point for different nonprofits. Every one of them, believe it or not, is a little bit different. It's not so simple, right? Every one of them is a little bit different. Are you going to require that at this stage of the game, they just have, the one shot of the J&J vaccine or 2 shots of the Pfizer or Moderna, or are you going to require that they be boosted? You're also going to require, if and when it's likely the CDC comes out with guidance at some point saying fully boosted means not only 1 booster, but a second booster. And, and that might continue, for years. Do you want to tie it to the CDC definition of being fully boosted, which right now, by the way, does not include that 1 booster shot. But that doesn't mean that you as an employer can't do that. You don't have to be, the CDC guidance is just that, it's just guidance. You can do whatever you guys want. And, certainly there are a number of employers that have vaccine mandates that are saying if fully vaccinated means, getting whatever boosters are recommended by the CDC at that time. And so you want to make sure your policies are written clearly in that regard. What sort of proof of vaccination you're going to require, how you're going to go about doing that. All of those things typically would be stated in there as well. And then the other thing that's really important on the employment side, and it's different for things like events, like most of your organizations probably have in-person events or have been or will in the future have in-person events, and the rules for vaccine requirements and exceptions from those requirements are different in the event setting than they are in the employment setting, with one notable exception. So but let's talk about employment first. And I see your comment, Michelle. If you want to, actually, you know what, you guys will all benefit from that. So let me make a note. I'll send to Dave some sample employer vaccine policies. I'll probably redact them, but that we've either written or edited or revised for our clients.
Yep, sure.
And that you can share with your whole group, not just those on the call.
Yeah, absolutely. Happy to do that.
All right, that'll be helpful to you. So in the employment setting, there are 2 federal laws that you got to be aware of. One is the employment provisions of the Americans with Disabilities Act that I referred to earlier. The second is Title VII of the Federal Civil Rights Act. And then many states have their own equivalents of both of these laws, many of which apply to smaller employers. Like I know a lot of your groups tend to be a little smaller employers, some are larger, but these federal laws have, they only apply if you have a certain number of employees, which don't cover a lot of small employers, but a lot of states have their own version. And keep in mind, I know this is one of the other questions we're going to get to, on the employment law side, the employment laws apply based on where you are, where the employee is principally located. So if you have remote staff in lots of different states, each of those employees is going to be governed by the employment laws in those states. Keep that in mind. It's not about where your nonprofit may be headquartered, it's where the employees are located. That's very different, for instance, to a lot of other laws that apply based on either where your organization is located, or things like on the governance side, nonprofit corporation statutes and whatnot, those apply based on where your organization is incorporated, not where it's located. So it can get confusing, but on the employment side, it's where the employees are located, which is why kind of remote work for all of its great benefits and virtues and you know the some of the silver linings of the pandemic, one of the biggest downsides is from a compliance perspective, because you have to now deal with these employment laws in all of these different states, which in some cases are very, very different from one to the other. And sometimes we have a lot of our clients that are trying to find like a lowest common denominator. Like they don't want to have different overtime policies for different employees or different benefits or other things like that. So you have to pick essentially wherever you have your employees working, you know, whatever kind of the lowest common denominator is, that if you want to apply it to all employees. But anyway, that aside, at the federal level, the employment provision saying it's Title II of the Americans with Disabilities Act says that if someone has a qualifying medical condition that constitutes a disability under the ADA that makes it dangerous for them or risky for them to get a COVID vaccine, then you have, and I'll talk a little more about that in a second, you have to provide a reasonable accommodation to that employee, so long as A, the accommodation does not pose an undue burden on the employer, and B, so long as with that accommodation, they can still perform the essential functions of the job. Okay. So in the nonprofit world, the two typical reasonable, and it's up to the employer to decide, by the way, not up for the employee to pick. The employer can determine as long as it's reasonable. In the nonprofit world, the two leading reasonable accommodations are, one, remote work. You know, so that if someone is just working remotely, the issue of a vaccine mandate is irrelevant if they're not coming into the office or traveling for work events or things like that. So full-time remote work is certainly one reasonable accommodation. And if that works, now it doesn't work for, you know, the meeting planner that has to go on site all the time to venues, to do site visits, to staff events, all of that stuff. It doesn't work, you know, for large organizations that have someone that's delivering the mail, you know, around the office. You know, that would not be a reasonable accommodation because it would not allow that person to perform the essential functions of the job. But for many other positions in the nonprofit world, that is a reasonable accommodation that you could make. Now, you don't necessarily have to, well, you don't have to, and you may not want to, because if you have a policy where you want all staff to be in the office, I don't know, 3 days a week or 2 days a week or whatever you might do, 2 days a month, you might not want to make an exception that allows someone to do remote work full time. But again, that's a reasonable accommodation if it works. The other one that we're seeing is testing and masking. So requirements for, you know, say, for instance, a negative PCR COVID test within 48 hours or 72 hours of kind of coming into the office, or traveling for work events or things like that, coupled with a full-time mask wearing mandate. Even if you don't have a mask mandate for everyone else, the person that you're making the accommodation for, if you have a testing and a masking requirement, that is kind of the other reasonable accommodation we're seeing. But you do have to make that reasonable accommodation. Now, we work with hundreds and hundreds of different organizations each year, so we see things all over the map, including requests for reasonable accommodations, essentially, you know, exceptions from the vaccine mandate based on the ADA. And this is all a work in progress. You know, there's still so many more unknowns than there are knowns. But so we've seen a lot of requests, and under the ADA, you're allowed to ask for like a doctor's note, essentially, to substantiate the medical condition. And we're seeing, you know, frankly, some very bogus, at least on the face to us and my clients, bogus kind of doctor's notes that make kind of generic, you know, non-specific reasons why, you know, just saying if someone is, you know, that they have a serious health condition and taking a vaccine would be dangerous for them. That's not sufficient based on the guidance that's out there so far. So far, the guidance that's out there from the CDC and elsewhere says that the only known so far medical conditions that would make it dangerous for someone to get one of the vaccines, particularly the RNA vaccines, the Pfizer or Moderna, would be if there's a known allergy to one of the ingredients in those vaccines, which is apparently pretty rare. And I've yet to see like a doctor's note that points to that. If someone said that, though, a doctor, medical professional said that, and it was credible, I would, if a client was advising me, I'd say we need to accept it and make the reasonable accommodation. But the reality is most of the doctor's notes have said nothing like that. And they've just been, very kind of generic and not specific enough. And based on that, what I've advised clients in those situations is that you can deny the request for the reasonable accommodation based on that doctor's note. Let them know why, let them come back with more specific information. What seems to be happening in most of these cases is that the employee ends up quitting because they just realize it's not a good fit for them. But anyway, so I throw that out there. The other reasonable accommodation you need to make is pursuant to Title VII of the Federal Civil Rights Act, which says that if someone has a sincerely held religious belief that prevents them from getting a vaccine, you have to make that reasonable accommodation. Now, this one is a lot trickier and a lot more difficult to deal with. And I've had clients that have had some real difficult times dealing with this. Most of the requests that we've gotten from employees of my clients for the reasonable accommodation based on Title VII point to the fact that fetal stem cells were used in the original research that led to the development of these vaccines, which, from what I've been told and what we've researched, is the same for many, many other typical over-the-counter medications like Advil, Tylenol, Benadryl, things like that, all kind of originally developed through that same manner. And so if that's the rationale for the request for the accommodation based on religious beliefs, you probably have some grounds to push back on that. And asking questions like, do you take these other medications, which are also developed in the same manner? The reality is that most of my clients they're not eager to push back on this because it's the standard of sincerely held religious belief is kind of difficult to challenge. If someone did not point to the fetal stem cell research as a rationale, but simply pointed to something else more general or whatnot, I think it actually becomes even harder to push back on that. And so most of my clients, where they're getting these requests, they actually are making the reasonable accommodation, the same accommodations I talked about before. Just the religious one's a lot trickier and a lot riskier from an employment liability perspective. So I know that was a long answer, but hopefully that answered your.
Yeah, thanks, Jeff. Thanks for laying that out so well. Just one quick follow-up or two quick follow-ups. One, for the testing and masking, option, like what is the typical frequency they ask for to be tested? Is it like weekly? I mean,
yeah, it's a great question. So, I mean, theoretically, technically, if you wanted to require daily testing,
well, that's what I was thinking, but
even PCR testing,
that seems onerous.
The challenge we're seeing with the home tests, even though they're more readily available now, thankfully, is that there's no way to show that test came from that individual. Mm-hmm. Right, or even that it was properly administered, because for any of you or us who have done them, there's no name identifier on there like there is for a PCR test. But if you wanted to require the employee to show daily proof of a negative PCR COVID test, say within 48 hours or 72 hours, and you can make them pay for it, you don't have to pay for it as an employer. You wanted to do it daily, or you wanted to do it weekly, or you wanted to do it monthly, or you wanted to do it before the beginning of an event or work travel or whatever, you can do that. It's really up to you. Again, your policy should set this forth. And obviously you want to be reasonable and balanced. I have some clients that are paying for those tests, others that are not, some that are having on-site, rapid tests on site at different events, either for staff to be tested and even in some cases for attendees to be tested. We didn't talk about vaccine policies for events, like for attendees. But that is, you can have them. A lot of nonprofits that hold events are imposing vaccine mandates for events. So we get into some stickier issues in terms of if it's a large event. Do you really want to have long lines of staff having to screen, look at people's vaccine cards and IDs and things like that? A lot of larger organizations are using companies like Clear and other apps that are out there where you can get people to upload their information and get kind of cleared in advance, which can speed things up and make it more efficient. Something to consider. But on the event attendee side, you do have to make that same accommodation under the Americans with Disabilities Act because of Title III, a different title of the ADA. for the medical conditions, but Title VII of the Civil Rights Act does not apply to event attendees. And so you do not have to make an accommodation for a sincerely held religious belief. We're seeing a lot of nonprofits that are imposing vaccine mandates and making the accommodation for both the medical condition and the religious objection, but they don't have to legally on the religious side if they don't want to. So it's just something to keep in mind.
Great, thanks, Steph. One more follow-up about related to employment. There's a question in the chat that relates to this from Teresa about, can you inquire if a potential candidate for employment is vaccinated? And if no, can you put it in the offer letter that vaccination is required for work?
Yeah, so it's a little bit, it's a fine line, but here's the way that you can lawfully do it. You should make clear what your policies are. Okay, if you have a vaccine mandate and how you require proof and all that other, if it's going to also continue to require boosters as the CDC recommends it, that kind of stuff. And then once someone, gets an offer before they come into the office, you can certainly and should require that proof of vaccination. But you want to be careful to not, in the job posting, you should state your policies, because you want to let people know. It's going to essentially let people know who are not vaccinated and don't want to be vaccinated that they may not want to apply. That's all fine and good, but what you have to be careful of, the ADA has some really strict issues. A lot of people think this is based on HIPAA, the federal healthcare patient privacy law. This is not for most employers, because most employers are not covered by HIPAA. This comes from the ADA, which says that you're not supposed to, like if someone asks for an accommodation, you can ask certain information about the medical condition and proof of that, but you're not supposed to ask probing medical questions like as part of the interview process, because that could be deemed to be discriminatory. If you end up not making an offer, someone could say, oh, you didn't make me an offer because of my medical condition X. And that's where it's dangerous. So the way to do it is to say you have a policy about this, make that very clear cut, say it verbally in writing, whatever, put it in the job posting, you can put it in the offer letter, but don't ask any kind of probing questions about what it is. And then if they do ask for the accommodation, then you go through the usual process. And by the way, the EEOC has some fantastic kind of FAQs, a ton of them on their website about all of these issues if you want more. Some of it might be a bit daunting. There's a lot of information there, but there's a lot of detail about what you can and should say and not say.
Okay, try to check those out. I had one more COVID related question on the list, but I wanted to, Susie, I know you had a question. I know you got to leave. Because we have a few questions about employee benefits.
It's okay.
We'll ask it. We'll record this if you want to check it out.
Wait, Susie, was your question the one about parking and transit?
Yeah, it was.
Yes.
Actually, so that's one of the few areas of law that I'm not an expert in, because your employee benefit stuff, you got to be full-time employee benefits lawyer. It's too difficult and nuanced. But we have like an outsourced employee benefits lawyer that we work with, Katrina. I asked Katrina the question, and here's her answer. I'll read it to you. She said, both qualified parking and transit passes can be reimbursed as an Internal Revenue Code Section 132F, what's called qualified transportation fringe benefit. And by qualified fringe benefit, what that means is that if you offer this benefit and it's within the federal, the IRS rules on this, then it's not treated as taxable income to the employee. And the IRS rules have dollar limits, and they change each year. Most years, the 2022 limit for qualified parking is $280 a month. And then there's a separate 2022 limit for transit passes of $280 a month. So if you are, for instance, say you're in downtown DC where monthly parking is more than that, say you were to reimburse, I don't know, $350 a month for parking. The delta between $280 and $350, $70, that part would be taxable income and included on the employee's W-2, but up to $280, free to design a program which has a combined limit of $280 a month, with the employee deciding how much to use for parking and how much to use for transit passes. So hopefully that answers your question.
That was great. Thank you so much. Okay, you can go back to everything.
Thanks, Susie. Well, now we also Susie also had a question. Where do we keep info data related to accommodation requests? Is that also something that you just, same kind of protection you mentioned earlier?
Yeah, like any
for
personal, medical information should not be kept in the personnel file, very carefully stored, password protected, under lock and key, so forth.
Mhm.
And only shared on a need to know basis with whatever staff or legal counsel needs to be aware of that.
And you may not know this benefit question about, is there a limit for phone internet usage?
So I say that again?
Is there a limit to reimbursement for phone internet usage for employees? Like, I know a lot of our members are reimbursing now for that because a lot of staff are working remotely.
Yeah, so
Um,
this much I do know. Again, I'm not an expert in this area, but for certain things like transportation to and from work, like those are not considered business expenses. So for instance, like an employee is not allowed to deduct, an independent contractor is different, but to and from transportation to and from work is generally would not be considered a business expense, meaning that if the employer is paying for that, it would generally be treated as taxable income. However, because of that exception for qualified transportation fringe benefits, up to those dollar amounts, it is considered tax-free. But then there's a much broader category of basically any business-related expenses, as long as they're done under what's called an accountable plan, and the accountants can speak to this much more than I can. There's certain rules about what's an accountable plan, about how you do it, how you require receipts, how you reimburse, things like that. If you, as long as it's, a business related expense and you're reimbursing it pursuant to an accountable plan, then that is going to be tax-free. It's got to be business related, and certainly, which basically means principally business related. So if you're providing reimbursement for internet access, of course, is there going to be a personal component to it when people are using their, internet access to stream Netflix at night to watch shows and movies, of course. But as long as it's principally for business purposes, that should be fine, and that should not have to be treated as taxable income. And I don't believe, again, don't quote me on this, but I don't believe there's any separate rules on that or separate dollar limits under the Internal Revenue Code. So as long as it's business related, that absolutely should be fine without any limits.
Great, thanks, Jeff.
Sure.
One other COVID question we have here. Are there any legal requirements regarding obligations to deal with people who catch COVID while at a conference or program that you are hosting? And if there are no legal requirements, what have you seen groups doing to handle this from a practice standpoint?
Yeah, I had that question at the event I did earlier today too. So there are no, as far as I know, it could be, with state and city and, county rules, there could be different specific affirmative requirements in some cities or counties. But I've never come across one. Again, there may be certain cities or counties are supposed to report things, to the city or county about, and sometimes even to the state about COVID cases and whatnot. But in terms of like mandates for if someone contracts, that someone contracts COVID at your event, what are you obligated to do? I'm not aware of any affirmative express requirements at the federal, state, or local level. But at the same time, there's always potential tort liability. That's liability for injuries, basically. For negligence, for instance, if so someone, say, let's make an extreme example. Someone has COVID and you knowingly let them walk around your event without a mask as they, cough up a storm and sneeze, and they're around tons of other people indoors that don't have masks, right? So again, extreme example. Hopefully, you don't have any attendees who would actually take that course of action. But if you had one that did, and if you knew or should have known about it and did not do anything about it, there is the potential that you could be sued by one of those other attendees that contracts COVID and has lots of, ends up contracting long COVID and has all these medical expenses that aren't covered by insurance and everything else. There is the potential that you could be sued for negligence, and they could even win that suit if that fact pattern existed, right? And so what you want to do is take steps so that you're not being negligent, so that you can never stop someone from suing you, but you can certainly maximize your chances of being successful in that suit. And so that's why, even if you don't have to have a formal policy on this, a lot of nonprofits get caught up in policies. I've got to have a policy for everything. I'm not a huge fan of that. Look, the more policies you have, the less people are even likely to read them. There are many cases where a policy is extremely important. It gives you protocols to follow. You can point to the policy for liability protection, saying all of that. Here, though, I think what's most important is you just be smart. And if you know that someone has COVID, obviously not letting them in your event. Like someone asked me at the luncheon presentation I gave earlier, if we know someone contracted COVID at our 3-day conference, should we reimburse their conference registration fees? Should we reimburse their travel expenses? Should we put them up at the hotel, for 7 days so that they can quarantine and so on and so forth? You don't have to do any of that. I think at a minimum, from a negligence perspective, you certainly need to make sure you keep them away from your attendees, right? Beyond that, it's really up to you. If you wanted to do any of those things, you're certainly welcome to. I don't think there's any reason you have to. Obviously you want to be humane and you want to, maybe if you can get them the discounted rate for the hotel room for however long they want to stay, do that. Maybe if you want to reimburse them the conference registration fee because you feel badly they couldn't attend, I don't see anything wrong with doing that. Beyond that, probably not things that most nonprofits would do. But the most important thing is keep them away from the rest of your attendees. And if they do, when they have to walk through the hotel lobby to leave, to do whatever, make sure they're fully masked, etc. And maybe provide them with an N95 mask or KN95 mask, things like that, to make sure that they have full protection, that sort of thing. It's all about not being negligent in how you dealt with the situation. Yeah, Joanne, you have a question?
What about for that extreme example you just shared? Would having a liability waiver, every registrant sign that, help at all? Make any difference?
So, Dave, that's a great question. It's a great question. So, I almost every one of these talks I get asked about liability waivers for conference attendees, for event attendees, and not for employees, because it's illegal to waive workers' compensation benefits. So effectively, you can't get liability waivers from employees. But on the event and conference attendee side, to me, it's a no-brainer to include a liability waiver, that says, look, and you want to make sure they affirmatively click and accept that they agree to those terms. Basically saying, and we have a model on our website, and I have other samples too if you guys need them. That basically says, look, I recognize COVID is a dangerous, risky, easily transmittable virus. I recognize that whatever ABC nonprofit does with its health and safety protocols, can't guarantee I won't contract COVID. And if I do contract COVID at your event, I agree not to hold you, the nonprofit, liable and any of its officers, directors, employees, et cetera. That's kind of the typical liability waiver. We also recommend building in a second part of it that says, and I, attendee, agree to abide by all of your COVID protocols. And if I don't, then you can make me leave or kick me out, and you don't get a refund, that sort of thing. Yeah, I'll send you the, it's on our website, but I'll send you a link to the model liability waiver. And if any of you want something more, other samples, because again, there's no one way to do this. Every one of them is a little bit different. Let me know, I'll be happy to send it to you. But in that extreme example, it's a good example where liability waivers generally will withstand legal scrutiny. If someone challenged them in court, they'll generally prevail. But one of the grounds where you can challenge a liability waiver, and you're almost always going to be successful if you were challenging it, is when the organization that's getting the waiver engages in gross negligence or like willful or reckless misconduct. And that extreme example would constitute gross negligence. So in that situation, if someone were to challenge the legal viability of the liability waiver in court, they would likely prevail if they could prove that you were grossly negligent.
Okay, so negligence trumps the waiver. So
gross negligence.
Gross negligence.
And this is what you learn in torts class in first year law school. There's a difference between kind of basically simple negligence, which it's just called negligence, and gross negligence, which is what it means. Really bad negligence. Not quite the legal meaning, but yeah. But they are very different standards and different consequences for each. from liability waivers to the amount of damages and whatnot. Yeah, and I'm seeing the chat. Basically, to me, it's the biggest no-brainer to use liability waivers for any in-person event, even including a luncheon. And it's super easy. It's just part of the registration process. If you're doing it online, just have a pop-up box where they click and accept. And people don't even, like, they're clicking and accepting COVID liability waivers in the way that we accept cookies when you go to a new website or something like that.
Mhm. Right. Great. So I want to get back to a few of the questions submitted ahead of time. Switching off of COVID for at least a bit, Jeff. We've got two questions in advance around having to do with employee manuals, employee handbooks. How would you go about making sure an employee handbook is state compliant and inclusive of all important policies?
Yeah, so first off, frankly, there is no substitute here. Multiple part answer. There's no substitute for working either with experienced employment law counsel, a lawyer like our firm or true HR lawyers. We're kind of generalists. We're kind of outside general counsel, but we do a lot of HR work. There actually are certain aspects of HR work, including employee handbook reviews, that we actually have outsourced HR counsel that we outsource that to, which is too nuanced and specialized for a generalist to deal with. So either, a good employment lawyer who knows the laws of that particular state, or at least generally, any employment lawyer who has clients nationwide, they might not know the employment laws of every state super well, but everything is easy to access online and quickly and easily research. If you have a lawyer who only has clients in one particular city or state, they're probably not going to be as good at being able to advise you in other states. But either working with a knowledgeable employment lawyer, or there are a lot of great HR consultants out there that, frankly, know the employment laws as well as a lot of employment lawyers. But you got to have, I think, a sophisticated expert to help you with that. And then the second thing is, as I alluded to earlier, your employees are going to be governed and protected by the employment laws of the state where they principally reside, or I should say where they principally work. So it's not like if someone like in the DC area where I am, if someone resides in Maryland, but they work primarily out of your DC office, they're going to be governed by the DC employment laws. Or actually, let me give a different example. They live in Virginia, like in Alexandria or Arlington, but they work in DC. They're going to be governed by the DC employment laws, which are much more employee friendly than Virginia's employment laws in general. California's laws, by the way, are the most employee friendly, in my experience, in the nation, which is why we have some clients that say their remote work policy says you can remote work from anywhere other than California. I mean, it's not a joke, it's a real thing. And it's because the employment laws are just so different there, and so much like the employee versus independent contractor test was codified into law. It's almost impossible to be an independent contractor in California. Overtime for non-exempt employees is calculated on a daily basis, 8 hours a day, as opposed to a weekly basis under federal law in most states of 40 hours a week. Just a lot of employee-friendly protections. But bottom line is, your employee handbook needs to be compliant with the laws of all of the states, obviously with federal law. And not all federal laws are going to apply to you based on the number of employees you have. Because like I said earlier, a lot of employment laws only get triggered when you reach a certain number of employees, like 15, 25, 50 are common thresholds. But at the state level, like in DC, DC has, DC equivalents of a lot of those federal laws that apply to all employers, even with one employee. So you've got to be aware of which employment laws apply. And then the handbook needs to be consistent with that. You can do it in two ways. You can do it, with carve outs, saying, this is the general rule, but for employees in this state or this state, this is the different rule that's going to apply. Or, as I said earlier, you could do like a lowest common denominator approach. If you want to have uniformity, you want to treat all the employees the same in terms of all these sorts of issues I'm talking about, then you got to pick essentially the most favorable provisions of whatever particular state or states you might have employees in, and then apply those to everyone. And in short, as you can see, even from what I'm just saying to you, there's no substitute for, working with an employment lawyer to do that. And it's one of the biggest um, consequences of kind of this whole new remote work environment that we're seeing that's come out of COVID. Because yeah, it's great to say, you know what, we've seen you can be just as productive and even maybe more so and more happy, employee satisfaction if you work remotely. The Great Resignation has caused so many employers to have to be more flexible in terms of allowing remote work and just to attract and retain employees. But at the same time, every time you have an employee who is principally working out of a different state, you got to deal not just with the state employment laws, right? That's one thing. That's a lot in and of itself. But all of the other laws that kick in, there's all these like corporate and tax and other registrations and licensing and other things like that, and workers' comp and unemployment insurance and all those other things that you have to start complying with. I mean, even our own, now we're a 5-person law firm, but when in 2020 we were a 3-person law firm, and our assistant, who started the first 2.5 months of our firm working in DC, she resided in Maryland. And once we went like full-time remote for, or pretty much ever since, not wholly, but pretty much ever since, all of a sudden, we realized that we had to, like, she was previously, we were previously registered for her for unemployment, compensation, insurance, and workers' comp in DC. We had to now register in Maryland because she was principally working out of there. It just creates a lot of burdens and costs on the on employers, and things that a lot of people may not be aware of. So you got to balance, right, the pros and cons in deciding your remote work policies. And by the way, Joanne, I see you have your hand up. I'll get to you in 1 second. We have there's a program you guys might be interested in, very interested, and I'll send a link to Dave. I'm gonna send two. I'm just plugging these because I'm really excited about both of these webinars, and they're both free, and they're both going to be, I think, excellent. The one on April 7th is it's something called like the top 5 HR challenges facing nonprofit employers these days. I put together a phenomenal panel of 4 incredible women who are just rock stars in what they do. 2 of them are like the head of HR for clients of mine, and then 2 other outside consultants. They're phenomenal, and we got all of the hot button issues are going to be covered there. I'd strongly encourage you to participate in that. And Dave, if you want to promote it to all of your membership,
Sure.
I think I'm really excited about that one. And then the day before, completely different aspect of law, but doing a program, another complimentary video webinar on unrelated business income tax for nonprofits. And it's kind of like a primer, an overview, hot button issues, corporate sponsorships, royalties, endorsements, convention income, advertising income, all of that kind of good stuff. So if you have an interest, or if you have colleagues in your, CFOs or finance department or whatever who do a lot of work in that area, and it's not just the finance folks, because a lot of these UBIT issues, we do this every day. We're reviewing just today. I took a look at a couple of contracts that my colleagues had marked up, and they were contracts between like a nonprofit and like a corporate partner, and how those contracts are structured, how the income flow is structured, what sort of benefits the corporate partner gets. All of that can have a significant impact on whether the income that the nonprofit earns is taxable as unrelated business income, or whether it remains tax-free. So there's a lot of important planning opportunities, and that's why, like we do a lot of trainings, for instance, for like folks in the development and marketing space, staff for nonprofits, because they really need to understand this stuff in order to help be able to promote and sell and structure the partnerships with the corporate partners in a way that mitigates tax liability. So anyway, for free programs that I think that you guys would benefit from.
Great, thanks, Jeff. Joanne.
Thanks. Jeff, I understanding this isn't your expertise, this employee handbook area or benefits. I can't, if that's the most employee-friendly state, it was the most punitive. I mean, it just conveyed, and our handbook that we used to have when I arrived conveyed like a terrible culture, you know, like you're not allowed to do this. If I call you and you pick up, you're breaking our law. I mean, it was just absurd line by line. And we do, and I can understand that we can't do this ourselves. I've heard loud and clear we have to go to our employers council, which provides a service. But I guess I'm trying to understand, like, what's the minimum you have to do so that you don't hand someone something that you have to say, and this is written in a way that I don't agree with at all, which
Well,
undermines the entire thing.
Joanne, it's a great point. First off, most lawyers are not that adept at writing things in, the most, user-friendly, employee-friendly way. So that's one area where, yes, you need that outside legal expertise or HR expertise, but you don't necessarily need them setting the tone for the culture of your organization, right? And look, in this day and age, when right now it's more challenging to attract and retain talent than in any other time in the 26 years I've been practicing law, you cannot afford to have an employee handbook that is written like that, right? I mean, first off, I worked on ours when we first started the firm. Granted, we're five-person firm now, but I wanted to make sure it set the right tone as well. And I had an outside employment lawyer who helped me put the first draft together, but I went through it and even modified some things because I want to set the right tone. And you have a prospective employee, a lot of times they ask, can I see the employee handbook? I want to know what I'm signing up for. And so, yeah, there's no question in my mind, especially in the nonprofit world, there's no reason to have a negative tone, to send a negative, give a negative vibe or bad feeling when someone's reading that. At the same time, there are certain things that need to be in there from a legal perspective. So I'll just give you one example that comes to mind. Like, employees might not like to see this, but you need to say something. You can say it as nice as you want to say it, but you need to say something like, your use of our email system and our computer systems, basically you have no reasonable expectation of privacy in that, and we reserve the right to review or monitor that at any time. That's critically important to say, the courts say, because that makes clear that the individual employee does not have a reasonable expectation of privacy, so that if you do, and so you suspect something bad's going on, you start surreptitiously reading their emails, you can't later be sued for some sort of invasion of privacy rights or something like that. So it's critically important to say, I don't care how you say it, you can say it as nice as you want. You can even explain the rationale for it, but you need to have that in there. If you have policies on when someone's eligible for benefit plans, or, when someone, you name it, there's a million different issues. Say it as kindly as you want to say it, but from a legal perspective, there are certain things that you still need to say. But I think it's a great question and a great point. Yeah.
Great, thanks, Joanne.
Thank you.
I know we just have maybe 10 minutes left. We had two questions, Jeff, that were related to, like, I would say, like, communications areas. One was, what are the regulations around signing people up for your newsletters or sending them bulk mail?
Yeah, I remember this. Let's do that first, because if I remember, the second part of the question was completely unrelated, or largely unrelated, at least from a legal perspective. So there's a law that's been in place. God, it's been around forever. I think I was going to law school when the law was enacted, or at least early practice of law, called the Federal Can-Spam Act. And it's basically what we have at the federal level in terms of kind of consumer privacy on the commercial email side. And what it basically says, I don't remember, I haven't spoken about this in a while. I actually wrote an article explaining this law when it was first passed and what it meant for nonprofits. But what it basically says is that if you are sending a commercial email, which is defined as any email where you're trying to sell someone a product or service, and that includes nonprofit products or services, membership, conference registration, publication sales, all of that. That's all a commercial product or service. There's no like general nonprofit exemption here. But if you are sending someone an email that's promoting a commercial product or service, including a nonprofit one, then You have to identify it as a commercial email, and you have to give them the opportunity to electronically opt out of that email. Now, this law has been around now for, my God, I guess over 20 years now. So there's obviously been a lot of kind of common practices, and you see it. I mean, you just look at most commercial emails, you know, at the bottom, there's like an unsubscribe or an opt-out link, which is more than sufficient. The rule about identifying it as a commercial email, I don't really see most folks doing that. So I'm guessing that's just something that hasn't been enforced over the years. That is the technical requirement. But the main thing is you have an electronic opt-out. And then, of course, if someone does, you have to honor that. And the best way to do it, in my opinion, is just to have a link. Ideally, one of those one-click unsubscribe links, at most 2 clicks, you know, where they click that and then they have to click that they confirm. Maybe you have the optional, here's, you know, give us the reason why, but whatever, that's up to you. But you have to do that if you're emailing anyone where there is not an existing, like, established relationship. So, like, the opposite would be, or the other construct would be, someone who's a member of your organization, or I'm trying to remember how it would apply with donors. Again, it's been a while since I looked at the details here, but basically there is this exception. If you have an established relationship, like established business relationship with the individual, then you actually don't have to do these things. That being said, most nonprofits tend to have the opt-out link, the unsubscribe link, regardless, even if there is that established business relationship. But technically, the way the law is written, if it qualifies there as an established business relationship, then these requirements do not apply. All right, Dave, what was that other question?
Yeah, well, the other
issue.
What was about what constitutes copyright infringement on our websites, and how do we avoid it inadvertently?
So this is a completely separate issue, unrelated, different area of law. So that dealt with the Federal Can-Spam Act. This deals with the Federal Copyright Act. The Copyright Act is all copyright law in the U.S. is federal. There's no state copyright law. That's very different and distinct from trademarks, where there is state trademark law. And I love speaking on these issues because this is an area of law that's it's not intuitive. So what you think might logically be the case in the law is not always the case in copyright law. And also the differences and distinctions between copyrights and trademarks, which get so many people confused, are also really important to understand. But so just so you know, the question was about copyrights, and I'll get to it. Copyright is the protection you get under federal law for original expressions of ideas that are fixed in a tangible medium. So think a book, a photograph, a video, a piece of artwork, a website. These are all generally original expressions of idea that are fixed in a tangible medium. They're subject to copyright protection. The person who creates that work automatically is the owner of that work, regardless of whether there's any copyright registration. And if that person is an employee that works for an employer and the work is within the scope of their employment, the work, it's considered what's called a work made for hire, and it's automatically owned by the employer. So for all of you that do work, within the scope of your employment, your work product is automatically, the copyright is automatically owned by the employer. If, on the other hand, nights and weekends, you're an aspiring artist, a musician, and you're doing writing music or painting or a videographer or whatever, and doing stuff unrelated to work, you own the copyright in that because that's not related to the scope of your employment. I know this is a multi-part answer, but there's a lot to try to unpack here. Another important point is that for non-employees, think volunteers, think contractors, even if you're paying someone to create something for you, if they're a non-employee, under copyright law, they are the owner of the work product, or their employer is the owner of the work product, unless there's something in writing that assigns the ownership over to you, or unless there's like an express or implied license of the work to you, which is why it is a best practice by far to be sure that anyone who is contributing or donating copyrightable works to you, could be members of a committee or a board creating some new work product, could be an independent contractor, consultant you're hiring to do some work for you. Whatever the case is, you want to have a provision in some written document with them, even with volunteers, that says either their work product is assigned, which means a transfer of ownership to you, or at least you get a broad license from them, which is permission to use, a perpetual, irrevocable, worldwide, royalty-free, unlimited use license to use that work product in any way that you want, obviously without having to pay them for it. It's really important that you do that with both volunteer contributors as well as paid contributors. And if you don't have that language in there, you might have an implied license, but you're not going to have much more than that. So all of that as background. And then just to contrast, trademarks, which are very different, are what trademark lawyers often call source identifiers. They identify the source of a product or service. So think, brands like, Nike, Coca-Cola, think United Philanthropy Forum, right? And the logo, that is a brand identifier, and that's a trademark. That's protected, completely separate and distinct from copyright, beyond the scope of what I have the time to talk about here today. But back to the original question in terms of infringement. So one of the rights of the copyright owner has a lot of different rights. They call it a bundle of rights, all these different rights. One of the rights is the right to prevent others from copying or using that work without your permission. There's one kind of notable exception to that called the fair use doctrine, which again is kind of outside the scope of what I have time to talk about here. Maybe we do maybe next time, when you solicit the questions, Dave, ask people to ask me some more questions about copyright and trademark, and I'll spend the first part talking about that instead of COVID and vaccines and all the rest. But basically, so that's one of the rights of a copyright owner. So if you own rights to certain material, say you have an article on your website, a white paper or whatever, something, and then someone else is using it and kind of passing it off as on their own or incorporating it into their own stuff without your permission, that can constitute what's called copyright infringement, unless it falls within this very narrow fair use exception. It's going to constitute copyright infringement. And copyright infringement, you can get significant penalties, financial damages, if someone else engages in copyright infringement. You can also get a court to issue an injunction where they cease and or order to cease and desist in using the copyrighted information. But that's one of the reasons why when you have copyrighted information, even though it automatically vests in the employer, it's really important to register your copyrightable works with the U.S. Copyright Office, because that gives you significant added benefits. Most notably, if you register your works like your website, your magazines, your journals, newsletters, white papers, within 3 months of when they're first published, then you can, if there's infringement later, you can recover statutory damages for that infringement, which go up to $100,000 per infringement, plus attorney's fees in most instances, which is very significant because in the nonprofit world, the alternative is having to prove actual damages, which is really hard to do in any meaningful way. So you really want to get in the habit of registering all of your stuff with the Copyright Office. It's easy, simple. You don't need a lawyer to do it. All the forms are available on the Copyright Office website. You file everything electronically for the most part. Very simple, easy process to do. And then the last point is use copyright notices. The little circle with the C around it, with the year of initial publication and the name of the copyright owner, your organization. Put that on the front page, the front cover of everything that you do. It provides another layer of protection, and it also can create a different disincentive for copyright infringement. So anyway, went a minute over, Dave, but hopefully that answers.
Oh, yes, this is great. We're at time. Jeff, thank you so much for spending this hour with us. Thanks everyone for being on. We have a brief programming val, if you could fill that out before you head off. I wish you all a great rest of the day and rest of the week. And we'll be in touch, Jeff, with some follow-up stuff.
I'll follow up with you, Dave, promised. All right, thank you guys.
Take care, everybody. Be well.
Great questions.
Bye-bye.
Thanks, Dave.
Thanks, Brandon. Hey, Dwayne, good to see you.
Likewise, I just wanted to say I saw the eval popped up and I thought it was spam and I clicked it away before I filled it in. But it was great.
No worries. Glad you could join us.
Yeah.
So, yeah.
Fives all across, whatever the questions were.
Okay. All right. Take care.
All right, and I'll get back to you. I saw the thing about Seattle. I'm checking out, but I'm hopeful, and I'll get back to you shortly.